did send out a note to us indicating whether you could make a statement to the jury. If you choose to do that, that would be appropriate, and any or all of you can make that statement if you want to at this time.
We, the members of the jury, as representatives of the citizens of Michigan, would like to express our extreme regret and apologies for what you've been through.
Thank you.
In January 2008, in a Michigan courtroom, a jury, in a gesture considered extremely rare in American courtroom procedure, had the courage and the compassion to offer an apology on behalf of the state of Michigan to 10 Michigan women prisoners for the years and years of rape, torture, tyranny, and retaliation they were forced to endure in Michigan prisons. Each member of the jury stood before the women in open court and publicly apologized to them for the abuse they had endured while incarcerated. The guilty prison administrators had already left the courtroom and were not present when the jury did what these defendants refused to do: apologize for the harm inflicted. This 2008 landmark case eventually resulted in a July 2009 settlement against the Department of Corrections for the state of Michigan, wherein they agreed to pay $100 million as compensation to end 13 years of litigation with about 500 current and former female inmates in Michigan's prison system, who alleged that the male officers raped, sexually assaulted, and harassed them, had engaged in a widespread practice of cross-gender pat-downs, touching, privacy violations, and systemic and aggressive retaliation imposed on those women. The Detroit News found in their own investigation that Michigan lawmakers and prison officials regularly interfered and blocked investigations of sexual abuse in women's prisons, stifled inmate complaints, and stripped away the rights of assaulted prisoners to sue for damages. The problem was compounded by the low priority given to the prosecution of guards charged with sexually abusing prisoners. And the responsibility for doing so was increasingly left to the Attorney General's office, which was the very same agency fighting the lawsuits against the department by women victimized by these same guards. In the United States, sexual abuse by guards in women's prisons is so notorious and widespread that it has been described as an institutionalized component of punishment behind prison walls. It took enormous courage for women to speak out, because when they did, there was retaliation from the guards. Amazingly, a Detroit News investigation found that the Michigan Corrections Department had let staffers with criminal backgrounds or multiple complaints of sexual abuse on the job for years. In 2009, former Governor Jennifer Granholm ordered the men permanently out of the female residential units. The story of how this case developed, was litigated, and was eventually resolved over 13 years is historic and is a testament to the fact that good civil rights lawyers can make a difference in the lives of many whose rights are under attack by governmental authority. Human Rights Watch, Amnesty International, the United Nations, and the United States Department of Justice eventually documented the systemic nature of the unlawful conditions and the Department of Corrections' complicity in creating and perpetuating this hostile prison environment. The conclusions of these investigations were a powerful indictment of the Michigan Department of Corrections' role in fostering the unlawful prison conditions and covering up the crimes of its male officers, and a powerful rejection of former Governor Engler's failure to protect Michigan's citizens. Prisons owe an affirmative legal duty to protect their inmates against abuse. Congress and 44 states have criminalized all sexual contact between guards and prisoners, regardless of consent. In this Insider Exclusive Investigative Special, we go behind the headlines in Prison Abuse, Michigan Prison Scandal, to meet with Michael Pitt and Cary McGehee, partners at Pitt, McGehee, Palmer, Rivers, and Golden, who were two of a team of 10 of Michigan's top civil rights trial lawyers who successfully tried the cases of these raped and sexually assaulted current and former female inmates. Joan Eukins, a former prison warden, admitted at trial that she was fully aware of the sexually hostile prison conditions from 1993 to 1998 described by Human Rights Watch as torture, yet did nothing to curb the massive abuses and thereby preventing the injuries to these women inmates. After 3 weeks of testimony from the 10 women, former Department of Correction employees, and esteemed prison condition and mental health experts, a jury of 7 women and 3 men returned verdicts in favor of all the women and against the Department of Corrections and prison administrators. The verdicts ranged from $335,000 to $3.6 million. Total damages awarded exceeded $15 million, with 6 women receiving more than $1 million each. With interest and court-awarded attorney fees, the judgment was worth more than $42 million. This was a momentous occasion for everyone in the courtroom. The women, their lawyers, the members of the public, and even the trial judge were moved to tears by this display of humanity and decency. As a result of the efforts of these lawyers, the unspeakable crimes occurring inside Michigan's female prisons have been essentially eliminated. More than 35 men have been successfully criminally prosecuted for their crimes. Mike and Cary have earned the highest respect from citizens and lawyers alike as some of the best civil rights trial lawyers in Michigan and in the nation. They have seen how the state turned its back on our mothers, sisters, and daughters at a time when they were most vulnerable and unable to protect themselves from the men the state hired to oversee them. They understand that prison abuse is one of the most serious, enduring, and divisive human rights violations in the United States. The problem is not just in Michigan, but nationwide, and its nature is institutionalized. And because of that, they are driven to fight for people who have been harmed by the willful or negligent actions of others. Because they never want another innocent victim to be tortured, raped, or sexually assaulted again in prison. No one in this country and no one in civilized society deserves to be sentenced to be raped and assaulted in prison like the Michigan prison guards did to Jennifer Pruitt, seen here testifying in open court to the daily torture she endured starting when she was just 17 years old.
So I had went to the bathroom and he came with me. He had to escort me. He was the door officer. And he stepped in to make sure it was clear. And then he came and he pulled his pants down. He opened his pants and pulled them down.
What did he tell you to do?
He asked me if I wanted it.
What did you say?
I was afraid. I didn't want him to have sex with me.
Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Royal Oak, Michigan. It is my great privilege and pleasure to introduce Michael Pitt and Cary McGehee to this show. Welcome to the show.
Nice to be here. Thank you.
Thank you.
Tell our audience a little bit about your firm. What do you guys generally practice?
Sure. The firm is Pitt, McGehee, Palmer, Rivers, and Golden. We were established 20 years ago, and we principally fight for clients in workplace situations, discrimination, civil rights violations. And we are trial attorneys. We take the case from the beginning to the end, and we fight where the fight has to be fought, be it in the negotiating table or be it in the courtroom. We fight to get justice for our clients.
Right. Today we are here about a case that is properly titled Neal versus the Michigan Department of Corrections. Cary, tell our audience a little bit about the facts of the case.
Well, this case is about a class action lawsuit filed on behalf of more than 500 women who were inmates within the Michigan Department of Corrections and who had been sexually assaulted, sexually harassed by the male correction guards.
And this took place over a long period of time, didn't it?
Right. Starting, the male prison guards were placed in the prisons in 1986.
Right.
And they were placed in the housing units of these prisons where the women shower, where the women undress, where the women sleep. And yet there were no modifications made in the physical layout of these facilities so that the men were viewing the women. They were actually instructed to view them to make sure that when they were in the shower that they were seen. They were told to pat down the women and given no training on how to properly pat down women. And so there was groping going on. The women were being physically assaulted on a daily basis. In fact, there was a quota given that the men had to pat down at least 5 women a day.
Was that, why did they have that quota?
Supposedly because women may be taking contraband into the
Okay.
prison or stealing oranges from the cafeteria and bringing it back to their room, although there was not very much evidence that any
Yeah.
of that was happening. And so this was kind of a situation where women were being physically assaulted daily.
Now, this case was originally filed in 1996.
Correct.
And it took something like, what, 13 years for it to be finally settled, which we're going to get into in a minute. The problems that were going on with the male guards taking advantage of the women, criminally taking advantage, because there's, I think in 44 states, it's against the law to have any contact with the inmates, correct?
Yes, even if it's consensual, so-called consensual sexual relations, it's a felony in Michigan.
Right. One of the aspects of this case that really interests me was how much the government delayed the justice in this case. And tell our audience a little bit about, either one of you, what this delay was all about.
Sure. When the case was originally filed in 1996, the state of Michigan Department of Corrections filed motions to have the case dismissed on legal grounds.
Yes.
And
what were those legal grounds?
legal grounds were that there was immunities,
Yeah.
legal grounds that the state civil rights law didn't apply
Yeah.
to inmates in the Michigan prisons.
And by the way, when it was filed in 1996, the Michigan legislature actually changed the law in 1999 to fit their purposes.
That's
didn't they?
right.
How did they change it?
They changed the law by making a direct reference to this case.
Yeah.
The legislature said, in light of the Neal decision, we are going to amend the Michigan Civil Rights Statute to make it, to prohibit women
Yeah.
who are in the prison from bringing sexual harassment complaints.
Yeah, I found this absolutely amazing because here are women, they've committed crimes, there's no question about it, but to take away the basic civil rights of them just because they're temporarily incarcerated, okay? I found that amazing that that the legislature would pass such a thing. And the governor at the time was who? Engler?
It was Engler.
Engler.
But subsequent governor, Jennifer Granholm, was the Attorney General.
Yes.
And she approved of this amendment at the time as the Attorney General.
Yeah.
Now later she did remove the men.
Yes.
That
10
was
years,
2009, almost 10 years later, she's removing the men from the female residential units.
Right. The law as it stands today in the state of Michigan in regard to do women inmates have the same rights as other citizens to file suits against their, the guards if they're sexually, harassed or attacked or whatever. What is the law today in the state of Michigan? Cary?
Well, at this point, the law amendment to the Michigan Elliott Larson Civil Rights Act was challenged constitutionally, based on the Constitution, based on the Equal Protection Clause. And a federal district judge, Judge O'Mara, found that it was indeed unconstitutional. And that decision was not appealed by the Michigan Department of Corrections or the state of Michigan.
Right.
And consequently, that is the law at this point. I'm not aware that there has been a lawsuit filed making an allegation on behalf of a female prisoner under the Elliott Larson Civil Rights Act where it's been challenged in terms of that decision.
Let's talk a little bit about your clients. There were 10 initially. Later, as the suit was settled, it was more than 500, I think. The 10 initial women that came forward initially, and they were very courageous. Some of them, like for example, let's talk about Toni Bunton. She was one of your clients. What can you tell our audience a little bit about her?
Well, she went into the Scott facility I believe she was 17 or 18 years old.
And the Scott facility is one of 3 women's prisons that were the subject of this case, correct?
That's right. Okay. Closed now.
Yeah.
And Toni almost immediately became aware of the pervasive sexual environment that existed there,
Yeah.
the coercive environment that existed. I mean, she soon, imagine being in an environment where guards control every aspect of your life.
Right.
What time you go to bed, what time you wake up, what time you go to class, do you go to class, who you visit with, family members, every aspect of your life is controlled by guards. And she soon found out that there was this expectation that the young, attractive women submit sexually to the male guards.
Yeah.
And that
And by the way, not all male guards were involved with this.
that's correct.
But a significant number. I think there were 32 of them that were eventually convicted criminally, correct?
Well, there were scores of
Yeah.
men who were involved in this criminal activity. Many of them escaped punishment. But back to Tony, she soon learned what the code was at Scott. And she became a victim of rapes and sexual assaults.
Yeah.
Her reaction, which was a typical reaction, she became reclusive.
Yeah.
She would literally hide in her cell
Yeah.
and would not socialize with the other inmates,
Right.
and lived with the shame of what was happening.
Now, when this evidence is just coming out, you know, these reports, these investigations, still the case is being held up in the court system, right?
That's right.
Why isn't anybody paying attention?
Well, you know, prisoners
Yeah.
are expendable.
Judges, why aren't judges paying attention?
Prisoners are expendable. Their political capital is virtually invisible.
Yeah.
It takes civil rights lawyers like ourselves
Yeah.
and Deb LaBelle, who really was responsible for bringing this whole case to the forefront.
She started in 1996.
That's
didn't
right.
She filed. She was the initial one. And talk a little bit about your team, because you had both yourselves.
That's correct.
You had Deborah, Richard Sobel, correct?
Correct.
Is it Patricia Streeter?
Streeter,
Shannon Dunn.
Shannon Dunn,
You had a whole team of people.
Molly Reno.
Ron
Ralph Serlin.
Ron Riosty,
Ron
Ralph Serlin. Deb LaBelle really was a satellite. I'm sorry, she was the mother ship, and
Yeah.
we were the satellites.
Right.
And she put together the team. We fought from 2002 all the way through 2009, when the case was eventually settled. For 7 years, the case was in active litigation. When I mean active, I mean depositions, motions,
Yeah.
hearings.
I do want to show one clip that was taken in the court of Dr. Karen Clark, who was the psychologist who brought up, and we're going to go to that in a minute, but the question was asked her, have you treated patients of sex predators before? And why didn't they report violations, et cetera? We'll show some clips on it right now.
A sexual predator is basically someone who carefully selects a victim and preys upon them. They study them. They might watch them. They might do some very deliberate things to develop rapport with them. And that rapport might be things like talking with them about very personal things, about family issues or about intimacy issues. They might give them gifts. They might offer them things. The things might be protection. It is usually very deliberate, and it's very opportunistic. And by that I mean that it's a studied situation, and it's studied in the sense that they are actually looking for someone who's very vulnerable and looking for a situation that's very vulnerable, and it is usually clouded in secrecy. The women said consistently things like, if you say something against one guard, you say it against all of them. And they felt that reporting compromised, jeopardized their relationship, their reputation with the guards, and even with other inmates.
As we can see, these women were gravely affected. One other woman that we didn't talk about, one other inmate, one of your clients, Jennifer Pruitt. when I watched her testimony, it seemed like she was a totally broken person. She went into prison when she was 17, and she may someday be able to get out of prison, right?
Correct.
Because there's a case that just came down, what, about 30 days ago, you said, from the Supreme
That's
Court?
correct.
Teenagers in the state of Michigan, right, who have been given the sentence of life without the possibility of parole, now can be resentenced, correct?
Correct.
And I understand that you're someone involved with one of these cases now, too, right?
That's right. There are 365 of these prisoners. These
Yeah.
are men and women that were convicted under the age of 17,
Yeah.
and they are now all eligible for resentencing. And a team of lawyers, not unlike the Neal team, is being put together as we speak to develop comprehensive resentencing hearings
Yeah.
for these men and women to see if we can get these sentences reduced, hopefully, to time served. I mean, that would be the wonderful thing to accomplish for these individuals.
I also want to point out to our audience that as a result of your case, there were 32, I think, at least, male guards who were charged and convicted of criminal offenses, correct?
Correct.
And sent to prison or sent to jail. Obviously, maybe they weren't sent long enough, but at least something was done. How, in a case like this, how can the government not be your adversary when an injustice is being done to people who deserve the basic civil rights? How do you get government to cooperate more so this kind of thing doesn't happen, or when it's discovered, they quickly remedy it? What's your solution to that?
The solution is what we did. You get the public to speak
Yeah.
through jury verdicts.
Yeah.
At the end of the cases, the jurors spoke. The jurors got it. The jurors understood what happened.
Yeah.
What had happened. The lawyers advocated for a better prison system.
Yeah.
We talked to the jurors about our prison system. These are people, our family members, our friends who are in our prison systems.
Yeah.
Don't we want a better prison system? Are you ashamed as a citizen of the state of Michigan to know that your state government
Right.
allowed this type of condition to go on for more than 25 years?
Right.
Shameful. Jurors got it. The state got it. They settled the case. The men are gone. Things are much better for the women.
This has been an amazing case. This is the reason we decided to come up here, because I think it's probably the largest verdict in a prison abuse case ever in the history of this country, isn't it?
Well, the two verdicts combined
Yeah.
was about $45 million.
Yeah, but I mean the whole total
The
settlement.
total settlement,
Yeah.
I think, is historic.
But it goes to show that even people who are incarcerated, people who have made mistakes, that they deserve the basic civil rights that anybody else does, no matter where you are, correct?
Well, and to some extent, even more protection, because they are in this environment where they can't turn the light off and
Yeah.
leave their office and go home at night and deal with the abuse in another environment.
Yeah.
We represent men and women in the employment arena who are sexually abused at work. They get to go home. These women never got to go home. They were literally prisoners in a environment of torture.
I wish you much success in getting some of these women out, especially the teenagers who were given life without the possibility of parole, who deserve it, who deserve a second chance. And I want to thank you very much for spending your time with us. This has been a monumental case, and you did a fantastic job. 13 years. Congratulations.
Thank you
And
very
thank
much.
you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at InsiderExclusive.com.